All right. I call this order for the Code Enforcement Board regular meeting scheduled Tuesday, February 24th to order. Could you do roll call, Christian, please?
Board Member Gallo.
Here.
Or Art Gallo. Board Member Steve Gilday.
Here.
Board Member Maurice Capra.
Here.
Board Member Joanne Krebs. Board Member Miguel Martin.
Here.
Board Member Jonathan Aubert.
Here.
And Board Attorney Amelia Ulmer.
Here.
No, Board Member Krebs did request to be excused as she is dealing with family medical issues.
All right. I would like to ask everyone to stand for a moment of silence. Jonathan, will you lead us in the Pledge of Allegiance, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Deputy Chief Presley,
Yes, sir.
do we have any changes to the agenda?
No changes tonight.
None tonight? All right. Do we have a approval from the board to approve the agenda for tonight?
Absolutely.
All in favor? Aye. Okay. Anyone, may I ask that any code enforcement officers or other individuals giving testimony tonight to please stand and be sworn in?
If you would just raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
If you are giving testimony tonight, when you come up to the lectern, I would ask that you state your name and address. City of Winter Springs personnel, if you could state your name and position. All right. We have some housekeeping tonight since we're a little late into the year. We've had a postponement of a couple meetings. So regular agenda part one is going to be the election of chairperson and the election of the vice chairperson. So as I've said, and not to be a redundant record, I've been in this position for a couple years, and I'm happy to serve the city in any way, shape, or form. So if somebody would rather sit here or wants, I take no offense or criticism, so I'm happy to do it. But if you guys feel that someone else is better suited, please speak up. Would anybody like to nominate someone for the chairperson for this calendar year?
I'd like to nominate Mr. Gilday for another following term.
Any other nominations? Okay. Do I hear a second?
I'll second.
Christian, roll call.
Sure. Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Martin.
Aye.
Board Member Aubert.
Aye.
And Board Member Gilday.
Aye. All right. How about nomination for the vice chairperson for calendar year 2026?
You want to do it again?
Sure.
Okay.
Probably a good question.
Okay, I'd like to nominate then Mr. Martin for a following term as vice chairman.
I second that. Christian, roll call.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Aubert.
Aye.
Chair Gilday.
Aye.
And Board Member Martin.
Aye.
All right. The next section is informational. Number 100, the Code Compliance Monthly Report. You guys are killing it. I went through and looked at the numbers and compared them going back pre-January, and code cases initiated 251. Open cases, though, dropped. I mean, it showed a drop up till the last time we met, and you're down to, I think, 45 from 60, and there was nothing, no code board cases. So, great job. We really appreciate the job you do. Thank you.
Chair, may I have a moment?
Please.
I want to mirror the sentiment. Thank you for all your efforts. I spoke briefly to you, Chief, about my suggestion to the board for a discussion now. This was brought onto our agenda as a suggestion last year. I'd like to keep it as such, but I would like to try to expand it if it's within our purview. This is outside of the police department, but this would have to deal with our city staff and getting a similar report for permitting. There's been a lot of inquiry on how many people have applied for permits versus permits that are open or permits that are being closed within that month. And I'm interested to hear some feedback from the board if we think that it should be added to this informational, because this becomes part of that public announcement that's sent out to the city.
I think with the frequency that comes up in conversation here, and also the points that you made, that's a great idea. You were going, I cut you off,
Yeah,
I'm sorry.
no,
Go ahead.
that's fine. I would say I've attended enough city commission meetings to know it's a topic that does come up more than you would think. And I think, Miguel, you're asking for how many permits, this would be once a month, how many permits were, applications were made for a permit? How many were approved, and how many
Open
open,
and how many closed within that.
something like that?
Yeah. Very similar infographic, you know, open, closed.
And then I don't know, maybe the city already has that data, and maybe the city clerk can explain if this is a difficult request or not.
Are you talking about building permits?
Correct.
Only building permits?
Permits. We have permits for arbor, we have permits for building, we have,
Right, so
Permits.
if I change out my hot water heater and I need a permit, you want that counted?
that would be a permit applied for. I think the general public is inquiring, you know, there's a lot of talk about, are they overstretched?
Okay. I agree with you. I think it's an absolutely great idea. I don't know that it falls within the purview of the Code Enforcement Board to gather that information. It certainly falls to the commission. But I don't know that we have no jurisdiction over permits. All we can do is enforce if somebody doesn't get a permit.
Correct.
I don't believe you're looking to enforce it, you're looking for just a
Just a public
snapshot,
information.
so.
I mean, I have no objection to it. I just,
Yeah,
what does the chief think?
I don't know, to be honest with you, because it falls under permitting. I don't know if they gather that information or if it's easy to get.
Right.
I would suspect that it probably is, but I don't know that for sure. I think that's something that, I don't know what that's going to look like. I know it's all computerized. I can go in and look at permits anywhere, any address on the public city website. So the data's there. I just don't know. And, you know, to Lynn, on what you said, you know, is it a function of the Code Enforcement Board? Probably not, but if that's information you want, I'm sure you could seek that from the commission, and they could have city staff
Yeah,
compile it as long as it's reasonable.
I guess my thinking here is, yeah, I'm not 100% sure it's within our purview, but it's certainly data that would be nice to know and reported, just like the police department comes out with these monthly stats. It's something to keep anyway. So maybe a way to go is to, little homework for the city clerk to find out, do they keep that data? Can they provide it? And if not to the Code Enforcement Board, then to who?
Yeah.
And I don't know if community development does a monthly report, a weekly report, an annual report, because it's a completely different department than the police department. They may already publish that, I don't know.
Okay.
We'll ask.
We can ask for the data. I mean, we can ask for the data. All they can say is no.
Correct.
So then I guess the formal request, Christian, would be if that is something that could be looked into and reported back to us of feasibility.
That's fine. Yeah, we'll ask community development and see what they're
Thanks,
able to
Chris.
do.
Thank you for the opportunity.
Thank you.
No problem at all. All right, move on to the consent agenda, I believe. We had, at our last meeting, minutes, I guess, for August were not available for review, for approval. So let's start there. Has anyone reviewed the August 26, 2025 Code Enforcement Board regular meeting minutes?
Chair, I have, and I have not found any irregularities.
Same.
Okay. Do I have a motion to approve?
So moved.
Second.
Second. All in favor?
Aye.
All right. Has anyone reviewed the September 23rd, 2025 Code Enforcement Board meeting, regular meeting minutes?
Chair, I have, and have no modifications to suggest. And I make a motion to approve as
Second.
written.
Second.
Have a second? All in favor?
Aye.
Aye.
All right. We have no continued cases, repeat cases, and that takes us to public hearing, new cases. Item 500. We have respondents Victoria Castro, Jose Castro, or Jessica Dawson. Is anyone present for this case? Do you, would you like to address this? Is this your case? No, sir. Okay,
I got this one.
okay.
All right, I'll get started. Right out of the gate, I'd like to correct the first slide. It should be February
For the-
24th, 2026.
For the record,
Yeah,
can
for
you-
the record, Deputy Chief Kevin Presley with the Winter Springs Police Department. And I would ask that the presentation and additional information presented tonight be entered in as evidence.
All in favor?
Aye.
This is case number 2025 CE 000642, and correct the date on the first slide. It should be 2026 and not 2025.
Okay.
Yeah. All right, IPMC 304.8 decorative features is what I'm presenting tonight. Cornices, belt courses, core bells, terracotta trim, wall facings, and similar decorative features shall be maintained in good repair with proper anchorage in a safe condition. Case summary, April 2nd, 2025, while Inspector Elbon was posting an unrelated notice of compliance hearing at the residence, Inspector Elbon observed the decorative column wrap surrounding the column adjacent to the front door at the referenced property, which failed to be kept in proper state of repair. It'll be exhibits 1 through 3 photographs. Exhibit 1, it'll be the column to the right. Exhibit 2, you can see where it's deteriorating. Exhibit 3, a close-up picture of that. On April 15th, a courtesy of 2025, a courtesy notice was sent to the property owner by USPS regular first-class mail. On May 19th, 2025, Inspector Elbon conducted a reinspection of the referenced property and observed the property remained in violation. Exhibit 4 and Exhibit 5 on those dates. May 19th, 2025, a notice of code violation sent to the property owners by USPS, certified mail and return receipt requested. On May 22nd, 2025, notice of code violation was delivered to the property owners. On June 23rd, 2025, Inspector Elbon conducted a reinspection of the referenced property and observed that the property remained in violation. Exhibits 6 and 7. See from the distance and a close-up, you can still see the rotting wood and decay of the stucco. July 31st, 2025, Inspector Elbon conducted another reinspection of the reference property and observed that the property still remained in violation. On October 2nd of 2025, Inspector Elbon conducted another reinspection and observed that the property remained in violation. There were also re-inspections conducted on November 9th, 19th, and December 11th of 2025, and the property remained in violation. Exhibits 8 and 9. As you can see, it's been now covered with a tarp. 10 and 11, same situation. So on December 15th, 2025, this case was reassigned to myself. I contacted the homeowner, Jose Castro, by phone, who advised that he had scheduled the column repair for January 15th, 2026. So at that point, I canceled our January hearing that was scheduled by Inspector Elbon, as it appeared that this was going to get taken care of. On January 8th, 2026, I contacted Mr. Castro by phone for a follow-up, and he informed me that the workers had been there that day and would be completing the repairs over the next couple of days. On January 23rd, 2026, I conducted a re-inspection of the referenced property and observed that the property remained in violation, and it appeared that absolutely no work had been done. Exhibits 12 and 13. As you can see, it's still covered by the tarp, same deterioration. So on January 23rd, a notice of hearing was sent to the property owners by USPS certified mail and return receipt requested. I also posted a notice of hearing at the referenced property and at City Hall and executed an affidavit of service, Exhibit 14. And as within the time frame that this was submitted, the return receipt was returned to sender for the notice of this hearing, but it was also posted at the same time. The inspection was conducted today by myself, and the violation, or the property remained in the same condition in violation. And that was taken today, this afternoon. So staff recommendation, staff recommends the Code Enforcement Board find the property in violation, issue an order requiring the violation be corrected and the property brought into compliance on or before March 26, 2026, which should be 30 days, and consider an imposition of a daily fine of up to $250 per day in the event that the requirements of the order have not been met by the date set for compliance by the Code Enforcement Board.
When you went out today, did you have any contact with the respondent?
No, sir.
No.
Has there been any contact with the respondent since your last phone call that was introduced on the record? when
No,
you
sir. None.
No. So, okay. And the respondent is not present to tell us what occurred between that phone call and today.
And the accounts that were given to you, none of them?
No,
Were
they're
accurate?
completely inaccurate.
Okay.
I was told by him that he had gotten that scheduled. That's why, we're like, cool, looks like we're going to come into compliance. Did the follow-up, and absolutely no work had been done, and it was all misinformation.
Anyone have any?
Yes.
Go ahead.
You mentioned at the start of the presentation that Officer Elbon was present in regards to another matter on that property. Has that matter been resolved, or does it remain open as well?
It has been resolved.
So they're actively trying to bring things into compliance. Ish.
They brought the old one into compliance. I don't know if they brought,
Yeah.
I don't see any
Any-
evidence that
yeah.
they're looking to bring this one into compliance.
Yep.
In fact, I hear of obfuscation and perhaps a neglect a neglect to try to really do what needs to be done. There's certainly a lot of prevarication in this.
No argument? Or anything?
No, I have no questions.
Okay. The case he referenced coming into compliance, I do want to remind, let's not take that into consideration on this. We're speaking about this case only. I have no questions or comments. It without having the respondent here and your feedback of, I mean, from the pictures, I looked at them before you, and I see nothing done. You've confirmed nothing done and inaccurate responses. So I'll entertain a motion if someone wants to go ahead, or do we need further discussion?
I'm ready to make a motion.
I'll hear it.
I move to find the photographs and testimony of Code Compliance Inspector Deputy Chief Presley clearly shows there is sufficient support to substantiate the issues present with the property as it relates to a violation of International Property Maintenance Code, IPMC 304.8, decorative features, in order that the respondent be given until 26 March 2026 to establish compliance. In the event that the violation is not corrected, a fine of $150 shall be imposed per day until compliance is reported to and verified by city code enforcement.
Do I have a second? Or do I have any conversation, discussion?
Yeah, how did you come to $150?
If, because of the false information provided to our inspectors, this could have been solved. Anyway, that's how I came up with the $150.
My feeling is that because this individual gave misleading information at best, he's going, I don't know that $150 is going to, is going to make a whole big difference to him. I would contemplate going higher than that.
Sure, I was just going to tell you my reasoning here is I thought about going higher, but under $50 a day for every day he doesn't meet compliance past that it's a lot of money. I don't know, I'd be interested in other opinions. I'm willing to change my mind, but that's what I thought was reasonable. Because it's not like a swimming pool that doesn't, open, and that's a danger, a safety thing. Anyway, I'd be interested in other comments from the board.
I would ask this question, Chief, this column is apparently degraded. Is there any danger of its collapse?
No, it's all decorative.
And my kind of leaning towards Art's suggestion, the 150 is the repair costs. Anything larger than 150 has a ability to escalate to be well beyond what a repair cost would be. I don't know if would catch his attention or not, but that's also something that I weigh. If you're trying to the whole point is to come into compliance. You don't want to be so excessive that it's beyond the repair cost. But would you be amenable to adjusting that to say $200 as opposed to the full $250?
I think $200. I think $200 certainly sends a message. It's not the most we can do, but it gets it. My problem with this respondent is the fact that he prevaricated. Had he attempted to do something, we wouldn't be here. Had he even bothered to show up here and say something, I would have thought differently. But he's totally blown this board off. And when you start blowing the board off, that's when I start thinking in terms of the higher figures, not the lower figures. So, yeah, I mean, I would certainly think that $200 would be an appropriate figure.
I was interested in hearing each of your individual commentary or feedback on this. I too have a problem with that he has, especially lying to you, more or less, citing that the repairs were taking place or people were there and nothing's done. That's pretty egregious. No communication as far as coming tonight and not showing up. It's not little effort. There's no effort here to communicate to work with us, so I'm in agreement with what has been said on the egregiousness of this, and I hope that, I'd ask you to take that into consideration. I do think adjusting upward would be advisable, and from my opinion, but I would like to hear from you folks, so.
Yeah,
John?
I agree. I mean, it's, with nobody here to communicate exactly what's happening, it's pretty cut and dry. But I do think the $200 amount, I think, would send a message, at least of urgency, to get it figured out and open up that channel of communication. So,
Okay.
yeah.
All right, I'm willing to amend my motion from $150 a day to $200 a day to be imposed until compliance is reported to and verified by city code enforcement.
And I would second that motion.
And we have a second. Christian, roll call, please.
Board Member Gala.
Aye.
Board Member Capra.
Aye.
Board Member Aubert.
Aye.
Vice Chair Martin.
Aye.
Chair Gilday.
Aye. All right, thank you all. All right, that takes us to item number 501. Respondent Nicole Comasio. Do we have anyone here to represent Nicole Comasio?
I got in touch with her sometime today. She stated that she couldn't return.
Okay. Before you start, would you please
Yes.
state your name and position?
Carlos Defoe, Code Compliance Inspector for the City of Winter Springs.
Okay. All right. Would you
Okay.
please give your presentation?
I will ask the board to accept this presentation into evidence.
All in favor?
Aye.
Aye, including the backup information that was present, not only this presentation, but all the information that was sent, correct?
Correct.
Thank you.
Okay. So for the record, the case number is 2026CE000121 for 1454 King Court, violations of Winter Springs Ordinance 13-2, subsection C, Winter Springs Ordinance 13-2, subsection E, IPMC 2024, section 302.7, accessory structures, and IPMC 2024, section 303.2, enclosures. Winter Springs City Ordinance 13-2C prohibitions, the existence of excessive accumulation of unintended growth of weeds, undergrowth or other dead or living plant life, or stagnant water, rubbish, garbage, refuse, debris, trash, including and not limited to household furnishings, and other objectionable, unsightly, unsanitary matter upon any lot, tract, or parcel of land within the city, be it uncovered or under open shelter, to the extent and the manner that such lot, tract, or parcel of land is or may reasonably become infested or inhabited by rodents, vermin, or wild animals, or may furnish a breeding place for mosquitoes, or threatens or endangers the public health, safety, or welfare, and may reasonably cause disease or adversely affects and impairs the economic welfare of adjacent property or any other objectionable, unsightly substance or material, tending by its existence and or accumulation to endanger or adversely affect the health, safety, lives, and or welfare of the citizens of the city, is hereby prohibited and declared to be a public nuisance and unlawful. So, Winter Springs City Ordinance 13-2, subsection E, I would ask you guys to observe. Move
Yeah.
to the next slide.
So yeah, for the board, the presentation's entered into evidence, so if you're okay, he doesn't have to read
That's fine.
the whole thing. But he got some good practice.
Yeah.
IPMC 2024, section 302.7, accessory structures. IPMC 2024, section 303.2, enclosures. On January 12, 2026, CCI Defoe, was reassigned cases initiated by CCI Albon on September 8th of 2025. Upon review, the cases were consolidated for administrative reasons and assigned a new case number, reference case numbers January 13th of 2026, I conducted an inspection of the reference property and observed that the property remained in violation, Exhibits 1 through 9. Exhibit 1, Exhibit 2, Exhibit 3, Exhibit 4, Exhibit 5, Exhibit 6.
Can I pause you on Exhibit 6?
Yeah.
That's a pool.
It's a pool, but question of the observation there, is that water or concrete fill?
Yeah, I thought so as well, but that is actually water.
Okay.
Thank you.
Exhibit 8, Exhibit 9. January 14, 2026, a notice of violation was mailed to the registered property owner by USPS certified mail with a return receipt requested, posted at the property where the alleged violation exists, and posted at City Hall, Exhibit 10. January 20 of 2026, Code Compliance Division received a voicemail from a respondent of the property. A callback was initiated, but the call was unanswered, and a voicemail was left for a return call. January 21st of 2026, CCI Defoe, myself, conducted a reinspection of the reference property and observed that the property remained in violation. Exhibits 11 through 18. 11. Exhibit 12. Exhibit 13. Exhibit 14. Exhibit 15. Exhibit 16. Exhibit 17. Exhibit 18. January 21st, 2026, a notice of hearing was mailed to the property owner by USPS certified mail with return receipt requested, posted at the reference property and City Hall. Exhibits 19. February 11th of 2026, a notice of violation was unclaimed and returned to sender. A notice of hearing remains delayed and in transit. However, for the record, that notice of violation was returned to sender, received back to the original. Exhibit 19. Staff recommends, that is today's photos. So that would be the opposite side yard from where you saw the water heater at. The water still unsanitary. Enclosure still in disrepair. Fence still propped up by support beams from the adjacent neighbor. Enclosure. Another section of side fencing in disrepair. Another angle of the pool enclosure. And the opposite side yard where the water heater is screened at from that portion of fence. Staff recommends the Code Enforcement Board find the property in violation, issue an order to abate the property for the violations of IPMC 2024, Section 302.7, and Winter Spring City Ordinance 13-2, subsection E. Second recommendation would be for the Code Enforcement Board find the property in violation of the remaining violations of IPMC 2024, Section 303.2, and Winter Spring City Ordinance 13-2, subsection C, to be corrected and the property brought into compliance on or before March 26, 2026, which is 30 days. Consider imposition of a daily fine of up to $250 per violation per day in the event the requirements of the order have not been met by the date set forth, compliance by the Code Enforcement Board. That concludes the presentation.
I have a question on this slide. It just has to do, and it could be I'm just not understanding, the code violations. In the introductory slide, there was 4. And I saw in additional information, there was 2 others, IPMC 2024, Section 303.1 on swimming pools and 304.7 roofs and drainage. But I didn't, are they on this one, or did I miss them, or?
No, so that notice was mistakenly put on the additional. There was supposed to be the actual notice that was posted at the property. I don't know if that was in the slide.
So are we looking at 6 potential violations? How many total?
4.
And none of them are swimming pools or roofs or drainage?
So 13-2 subsection E, it shall be the duty of the owner of each lot, tract, or parcel of land within the city to reasonably regulate and effectively control excessive growth, accumulations, and unenumerated in section C, and/or dead, damaged, or diseased trees in subsection D on the property. Hold on, let me get to the part. Oh, it shall also be the duty of the owner to drain, regrade, or fill any lot, tract, or parcel, including swimming pools, thereon, and shall be unwholesome or sanitary, have stagnant fall water, or be in such other condition as to be susceptible to producing disease or danger to the citizens of the city.
To make it simple for me, name all of the, because I still don't, I'm not following, name all the ordinances that we're looking at that are in violation. So,
13-2 subsection C
okay,
For what?
for the overgrowth.
Okay,
And then 13-2 subsection E for the swimming pool.
okay,
okay,
And then 1302.7 accessory structures for the fence.
okay,
And then subsection, I'm sorry, IPMC 303.2 for enclosures.
that's the pool.
The pool enclosure, correct.
okay.
I want to point out that the city ordinance 13-2 subsection C has mention in there for the water and breeding of mosquitoes. So I think there is a carryover for both on the pool. And also threatens and endangers the public health and safety and welfare. I know this board has discussed this prior with pools. My observations is from the evidence shown today and is all presented to us today. There is zero barrier between anybody in the neighborhood and opaque water. Not just stagnant water, opaque. So if something or someone or some child were to fall into this pool, no one would see it.
Correct.
So are we looking at 4 to answer my question?
Correct. Four of the, 4 of the ordinances given.
Okay, and the swimming pool being a safety issue here
Yeah.
is part of that.
Absolutely.
Correct. That'll be based on the first recommendation to abate.
Okay, I think I got it now, I'm sorry.
I have a question to ask you, Inspector. Did the notice to the respondent include the fact that the city would move to make corrections to that pool?
Correct. There is a section on the notice on the reverse side where it gives the description of the ordinances. There is a context for subsection 13, I'm sorry, section 13.4, which basically notifies the owner that code enforcement board could do an order to abate the property if actions or corrections have not been made.
And that if the city abates the property, then the homeowner is responsible for that amount.
Correct. So if that order is put in place, there's a process, and when the corrections are done, whatever costs or expenses that incurred from that would actually go forward to as a lien.
Of course, no, yeah, I understand that. Here's my concern. My concern is that in the past, when we had other counsel here, you're great. I'm not trying to minimize you at all, okay? But we were always cautioned that the notices had to specifically say, if you don't do this, the city will, and you will have to pay. And I don't know if that's included in this.
All right, if you allow me, I'll read you the section. Okay, so it says, "The property owner is hereby notified that pursuant to section 13-4 of Winter Springs City Code, the Winter Springs Code Enforcement Division will seek an order from the Code Enforcement Board for the city to enter the property, perform, or contract others to perform the work to repair or secure the property. The Code Enforcement Board may render an order requiring the city to perform the repair work. Failure to repair the property or follow the Code Enforcement Board's orders may result in city work to accomplish the repairs, and the cost of which shall be charged as a lien against the property. Upon completion of the work by the city of Winter Springs, the code official shall certify that the cost borne by the city in an invoice and shall serve the cost certification upon the property owner by certified mail, return receipt requested. Within 15 days of receipt of the invoice, the property owner shall have the right to request a hearing before the Code Enforcement Board to show cause, if any, why the costs and charges incurred by the city are excessive or unwarranted, or why such costs should constitute a lien against the property. The Code Enforcement Board will conduct a hearing and render a final order on the amount of costs and charges, and if any, that should be opposed against the property as a lien.
All right, so we've covered the fact that we've covered the fact that we've notified them that we can make, that the city can make repairs and charge them. Am I, right, so we can make repairs and we can charge them. Do you feel at this point that this pool is a jeopardy to the health and safety of the residents?
I believe so. Based on the information I received during my investigation of the property, it seems like this pool or the conditions of this property has remained in such a state for a good number of years. I wouldn't venture off to say that for sure someone will venture into the property and do so, but it is a potential hazard for anybody to.
Is the pool secured?
No.
So anybody can just walk in?
Correct.
There's no fencing around it or?
Correct. So.
Or the fencing is broken or whatever?
Correct. So being that there's an existing enclosure there, the property owner does not have the option of removing it. All they can do is repair it.
We understand.
Now, the screened or barrier, approved barrier, which would be the accessory structure or fence,
Right.
would be a substitute to secure the property, having free access to the pool.
All right, so what I noticed, I noticed the pool's enclosed by a cage.
Correct.
Is
Empty
that
cage.
cage totally sealed, or can somebody walk in?
No, that is damage upon the side entering to the property building.
Perfect, that's all I needed to hear.
Yeah,
Thank you.
and I would also point out, if you look at the property appraisal record, this is smack dab in the middle of a high-density residence.
Of course,
The property also is situated in the back of a cul-de-sac,
right.
so even more secluded and unobserved.
Yeah.
I would lean that this constitutes a safety hazard to them.
Absolutely.
Absolutely, and when we're talking about abating now, we're talking about doing two things. We're talking about repairing the enclosure. You're shaking your head no.
No, so what we're looking at, and Deputy Chief might be able to tag into this, what we're looking at is to treat the water or remedy the swimming pool to its proper state, and then also securing the property, so whether it be repairing the fence to secure that rear yard from anybody accessing the pool area.
So that's what I'm saying.
Yeah, the pool enclosure, that
I don't
would,
care about,
yeah.
I don't care about
the
whether it's, I don't care how, but the city wants to ensure that nobody can enter onto that, into that pool area, so that pool area is totally enclosed, and that the water is no longer stagnant, but is treated and is devoid of algae and other bacterial growth.
Absolutely.
That's,
Yeah, can I add to that? It should be also put on a filter or otherwise normal
otherwise it'll happen
pump
again.
system to maintain it, or else it's just going to degrade again.
I would agree.
So the pump would need to be evaluated in that abatement.
For the record as well, the property owner did make contact with me today. She advised that she wouldn't be able to attend the meeting due to work issues. She provided a couple documentations from Golex Properties LLC, which is the supposed buyer of the property. They're going through some type of contract right now, and there's another document given to me.
So this is the first you've heard from the owner?
No, so I received a call from the owner back in January. There was kind of like a disconnect, trying to get a hold of each other. Then she contacted me again about a week and a half ago, informing that she wants to correct the violations, but due to financial issues, she's going through selling the property and is waiting for the LLC to finalize on it. Then today she called me and afforded me a contract which stated that the LLC would go ahead and assume ownership of all the violations to get it corrected. However, the property is still owned under her and not by the LLC.
I have another couple of questions to ask. This case was consolidated, this new case was consolidated from prior cases that Inspector Elbin had, am I correct?
Correct.
All right. Do you have any record of any contact that Inspector Elbin had with this individual?
So the property owner did say to me that she spoke to Elbon, or Inspector Elbon, a couple times. I don't recall exactly what discussion was taking place between them. She did say that there was some type of direction of how to correct the violations, but that was back in September, and the property still remains in violation since.
And when did this whole litany begin? When was the first of these cases filed?
Based on Inspector Albon's notice, the inspection was taking place on September 8th of 2025,
The first one?
the first one. The second one he did was on October 23rd of 2025.
So there was no prior history to this before? This case was initiated in September of 2025?
Correct.
So it hasn't been ongoing that long?
Not from the information I got right now. I mean, I could dig in a little further, but anything of recent, no.
Thank you.
Any other questions? This, you spoke to the property owner. Was this a rental or is
No, this is
it occupied?
homesteaded. This was homesteaded, belonging to the property owner. I guess the property is being sold for financial reasons, and supposedly the property owner stays there, but it's not constantly present on the property due to work.
Okay.
Yeah. That doesn't affect us in
No,
any
I
way,
just
shape,
was-
manner, or form.
I just was curious about that.
So am I.
Is there anybody here to speak to this?
Yeah.
No one.
No, there's no
Here.
respondent, but I think there are other people here who might want to speak.
Okay. All right. I would welcome any comments from you if you'd come up, state your name and address.
My name is John Swanson. This is George Talik. We own the house directly next door at 1456 King Court. We've been there for 5 years. What's this? Put this up. I wanted to answer some of your questions that they're not aware of. The roof caved in more than 2 years ago. So it's been that way. And as you saw in the pictures, it disconnected from the house and fell forward. And it's in shreds, and it's still that way, and it's been that way for over 2 years. Wow. And the weeds and stuff have grown on it. It looks like a mess now. The pool has not been cleaned in 4 years. The pump does not work. It broke 4 years ago. It is black, as you saw in the pictures. It's filthy, and it smells terrible. The fence is down, and it is a hazard, and we have tried so hard because we have young kids in the cul-de-sac, like 3 and 4 years old, and they play there all the time, and our neighbors have pets, and they could go in there and get hurt or drowned. It's awful. The fence is down, and it's been down more than almost 3 years now. The 2x4s, the 8-foot 2x4s, we put up because the fence was falling over. Onto our property. We have that property next door. We put that up there. Her boyfriend took them down and threw them against our house. And we don't know why. We thought maybe they were going to fix it. Well, we put them back up because we were afraid it's going to fall over. The place, and this began a long time ago because I filed the complaint on September the 8th.
Okay.
I have been working for over a year with the Homeowners Association, Brian, the president, trying to get some of this stuff done. He has done the same thing. He has sent letters, certified letters that have never been signed. And we have seen the mailman come with the certified, and she's refused to sign them. She's refused to answer the phone, and she's refused to call them back. And what was his name, Elbon?
Yes.
He had the same problem, because he had to get permission to come on our property to see the back there. And he would tell us that he's left her messages, and she refuses to call them back.
Okay.
So,
With her, it's always, I'm gonna do it. I'm working with an insurance company. I'm doing this, I'm doing that. I have photos from April 2024, 2 years ago, in my phone of the pool and where the house collapsed, the fence fell down. So we submitted it on September 8th because our HOA spent a year sending her certified letters. She never signed for one. This is in our own development. So we ran out of patience with our HOA and we turned to the city. So to say this has been gone on September 8th and no one's done anything is not the truth. April 2024, I have Photoshop pictures of all this, and it's never ever changed. She won't talk to us. live next
we
door.
haven't had any trouble. We've never had any arguments, but like we go over to talk and she'll close the door or close,
Same thing she does with the
garage
code
door.
enforcement and our HOA. She just disappears. You
she
know,
has done nothing to clean the house. There are beer cans, pop bottles, plastic, food paper, all over the place. There must be thousands of cigarette butts all over it. The garage is filthy.
Okay.
It is a horrible mess. And let me mention that we're hoping that you'll give her the maximum because we want this fixed. She comes from a wealthy family, so giving her a small fee isn't going to do any good. They owned all the Dominic restaurants. Her family has over $1 million house on Arabian, and there isn't any reason that she can't get this stuff done.
It's been so bad that we've contacted 2 different real estate companies. When the real estate agent
Because we were going to move.
walked, because we don't like living there. We love living there. That's why we bought the house there. They walked down that side of the property. What is
And they
that?
said, you're going to have trouble selling this with that
We're
neighbor.
not gonna be able to sell the house. And that hurts our real estate value.
Absolutely.
I mean, it's 100% hurts us. So we went to one agent, then the second agent said the same thing, and we said, let's don't go to a third because it's embarrassing. We're embarrassed. Our family, they don't like it. Nobody likes it. Nobody in our cul-de-sac,
It's
we have like 8 houses.
embarrassing for us to have our family and our friends and our guests over there because the house is so bad. So we're asking for you guys to help. And these guys have been really nice, both of them,
Yeah.
Deputy Chief and Carlos. So we
Somebody-
really appreciate the work
Somebody
that they've
mentioned
done.
about getting the pool together and all that. It's been, I don't know, a year and a half, 2 years ago. We heard water outside, and John ran outside. Their pool pump sprung a leak. Okay, John runs over to their house. She's on the front porch, and he tells her, your pool pump has sprung a leak. She shut the pool pump down.
And it's never been done since.
So as far as draining the pool and getting that secured, you're gonna have to repair the pool equipment, because that's been neglected. It's just nothing but a disaster. And
She
this
had
is
a-
in the tennis villas in Winter Springs. It's a nice development.
She had a car for months that didn't run, a truck parked in the driveway, flat tires, expired license plate. That was one of the violations I think that they had before.
got rid of the
But they towed it out, so that's why one of them is missing. I think you were asking about other violations. I think that was one of them. So, I guess that's about
Yeah,
it.
it's just that, it sounds sad that she's having financial problems. Everybody has financial problems. But this has been going on for 2 years.
Yeah.
It
And
hasn't
she
been
told-
going on since September 8th.
That story that she told him about the LLC, that's been going on for months.
We heard that back in
6 months
November.
ago.
Yeah.
Okay.
So we don't know if it's really true.
All it does is postpone, postpone, postpone.
Okay.
So,
Well, we appreciate your
Thank you.
input. Before you step away, does anybody have any
okay.
Yeah, any other questions that we know that they might not know?
And just to clarify the statement, you mentioned the roof had caved in. It's not the roof of the primary structure, it's the roof of the pool enclosure, correct?
No, it's the porch,
It's the porch.
the metal
that has
porch.
been attached to the
And it
house.
was not a storm that did it.
Yeah, yeah, but we can't address that. It's not,
That's not one of the,
It's not
uh,
one-
If it is on the enclosure, it is, yeah, I'm looking at the
It would-
photographs,
if
Exhibit
they did
5
the
and
enclosure,
Exhibit.
They'd have to do that too.
Correct. If they was to basically repair the enclosure, that portion would be resolved.
I just wanted to
But there's-
clarify for the
That
record,
is
it was
fine.
not the primary roof.
But
it's
with the aluminum and the roof, when it's windy outside, all that blows. It could
Sure.
come in and break our windows in our house.
Absolutely.
And there's a lot of things going on there. If you guys went out there, these pictures he took are wonderful, but it's devastating in person. For us.
Any questions?
no,
Did we let you have it?
Yeah, not for you.
Wow,
Okay.
sorry we're
Okay.
upset, but it's.
No,
But
no,
this-
that's
no, no, we
that's
understand, no, we
understandable.
understand you, absolutely. I have a question for Christian.
Thank you.
Christian,
We appreciate you, thank you.
Christian, how long will it take us to get an order out to the owner of this property? How quickly can we do that?
What you're talking about? Whatever you're talking about the board order.
I'm talking about a board order, that's
Oh, the
correct.
board order. Oh, okay. Well, probably draft it tomorrow. So,
I'll look
probably
at it as soon as I get it.
right. So
this is-
probably Thursday.
Yeah.
I mean, Thursday we could be in the mail.
Yeah, just a couple
Okay.
days.
All right,
Yeah.
all right, so if we were to give them 7 days I just want, I'm figuring in my mind now that this is going to take more than one motion. There's going to have to be at least 2 motions involved in this.
To
I
abate.
think you're on the same track in
Yeah,
my
one
head.
to abate,
Yeah.
one. So I'm figuring at least 2 motions. But if this one to abate, if we could get that motion, if we give them 7 days, is that enough time? I mean,
That was my
I don't
question.
care about them.
What's the process, what is our due process
I don't
time
care about
limit?
them. Is it enough time for you guys to get it out, to get that drafted and mailed out so that they would have it?
I have to ask the chair what his week looks like as well. He has to sign it.
I'll get over here, whatever you need.
Okay, so we'll have it drafted tomorrow, assuming
And I'll come tomorrow or
assuming
I need
the
it.
attorney is able to review it. I would say probably Thursday would be when it, because even if it's reviewed by the end of the day, it's not going to go out in the mail until Thursday.
Right.
Okay, thanks.
Thursday.
This is a bit unusual, so for me, who's a little ignorant here, what's this abate process?
Abate means
How-
that the city's going to come in and fix the problem.
we'll intervene as the city of Winter
Right,
Springs.
the city of Winter Springs is gonna come in, we're gonna give them X
Okay.
number of days, we're gonna give them
Okay.
X number of days to fix it. And if they don't fix it, the city can come in then, and the city can fix it, make any repairs, and bill them. That's what that's what the
Okay,
abate.
and that would apply to which one of the?
It'll apply to the enclosure in the pool.
Mm-hmm.
Because those are the 2 items that they're asking to abate,
The safety
the
concerns.
safety concerns.
Well, can't the safety concern be satisfied with a total fence around the area too?
So
No, because you still have the stagnant pool.
Yeah.
So the abatement recommendation was for the pool to be addressed
Right.
and for the accessory structure.
Right, that's the
Yes.
enclosure, right, that's what I'm saying.
The enclosure is separate, so the accessory structure would be the fence.
Defense, they're fine.
Yeah, yeah.
That's fine, all right.
Okay.
In that case, I'm prepared to make a motion.
1 second before you make it, council, can you just confirm with, as per fines, both for, on a new case, the maximum amount per an issue?
Sure, yeah, so for the ones, not the abatement ones, the ones that are being fined, it's
Correct.
$250 per violation. So, just in your motion, if it's the same fine for both violations, just highlight that it's X amount per violation, or if it's different amounts.
Per
say that as
violation
well.
can be 250 and then repeat can be 500.
That's
Right.
correct,
Correct.
right.
And I
Just
just
wanted to
want to
confirm.
confirm with council, if I think your motion is going to be rather short in time frame. What is our limit on the due process time frame? Have they had enough time to respond since this case was consolidated for us to make a motion for 7 days?
I would say so. I mean, city has complied with all of the due process requirements to this point.
Just wanna
and
make sure we're
she'll
within
get
our
the,
bounds.
She'll get the order, and then she'll have an opportunity to, contest that after she receives it. It's definitely a threat to, a potential hazard to the public safety and welfare. So I think if the board finds that 7 days is an appropriate amount of time for that abatement, that would be fine. 7 days, 10 days, however long you all see fit. I would say probably not less than 7 days, but I think 7 days would be okay.
Okay.
All right.
Okay.
I'll hear a motion if,
I move to find that based upon the photographs and the testimony from the officer and from the witnesses, show that that the pool and the enclosure and the accessory structures are in violation of the city codes, Winter Springs City Ordinance 13 TAC 2, paragraph C, Winter Springs City Ordinance 13 TAC 2, subparagraph E, and IPMC 2024, section 302.7, accessory structures. And that and respondent is in violation of those. I move the response be given 7 days from now. So today is the 24th, 31st, until February 3rd.
March 3rd.
I'm sorry, March 3rd, 2026, to correct the violations. In the event respondent fails to comply by this date, a fine in the amount of $250 per day per violation shall be imposed until compliance is reported to and verified by the code enforcement officer. Further, these violations constitute a serious threat to the public health, safety, and welfare. And in the event that the respondent does not correct the violation by the date set in this order, the Code Enforcement Board may notify the City Commission, and the City Commission may then authorize the city to make all reasonable repairs which are required to bring the property into compliance, including repairing the pool equipment that is necessary to maintain the pool, the fencing structures, and anything else necessary to ensure the public safety and welfare of that pool, and charge the violator with the reasonable cost for the repairs, along with the fine imposed pursuant to Chapter 162 of the Florida statutes.
before I ask for a second, I'd like some discussion. You mentioned Winter Springs City Code 13.2C,
Correct.
13.2E,
Yes?
IPMC 2024, section 302.7.
Correct.
We also, and I understand that we're not addressing for the abatement, IPMC 2024, section 303.2,
Correct.
enclosures. But do we want to include that?
That's going to be a separate motion.
That's, can we, and this is probably a question for council, can we include that at a different time frame than the 7 days is what my question
Right.
is.
Yeah, sure, yeah.
So that could be included onto his motion along with 30 days for that particular
Sure.
one.
Yeah, you can
And
add it
whatever
into
fine.
the
Yeah.
same one or do a
We
separate
could,
one, whichever.
for clarity, I would keep it as two separate motions.
We could do
I
that.
just have one concern. There's a distinction between accessory structures and enclosures,
Correct.
correct? The one that you are excluding is the enclosure, and it is my belief that the enclosure is what constitutes a public safety and welfare issue, because without the enclosure, there is no barrier, self-closing barrier to that pool.
Okay.
If you just say accessories, that they could put up a fence and it doesn't have self-closing latch, the kid could leave it open. So I would flip-flop that. I would include your two city ordinances, 13.2 Charlie, 13.2 Echo, and 303.2 would be my suggestion.
I was just trying to respond to what code enforcement officer said.
Is that your
I have no problem
understanding, Deputy
changing it.
Chief?
Well, our recommendation is to abate 302.7 of the IPMC 2024, the accessory structure, which is the fence. As, you know, the code official, I'm not so much concerned about the gates and stuff, as long as the property is secured from people getting in there. It doesn't have to have gates, theoretically. So our biggest concern is what's the quickest way to secure the property for safety? It's not getting a contractor out there to redo the pool cage and rescreen it and everything. It's not the most cost-effective way to secure the property. The most cost-effective way for the city is to put up a fence to secure it by several different means, and that's something typically we do in-house. We may have to contract some of that work out.
Okay.
And then the second thing is the water of the pool, to clear that up under 13.2 subsection E. We're well aware of the pump, that if you don't have a circulating pump, that the pool's going to grow algae. We don't know what that's going to take at this point. It will probably take some professional help because of the condition that the pool is in. It's not pouring some shock and chlorine in it 5 days in a row. I think we're beyond that as a pool owner. I don't know if it's going to have to be pumped out and new water put in, but there's some serious water quality issues there that'll probably have to be addressed by.
Or it can just be
Contract.
pumped out.
Right, but there's some
It's got to stay pumped.
other things, yeah, with the weight and the water table and stuff like that. If we lift their pool, then we're responsible for that. So we got to do our due diligence on, get some expert advice on that. So that's why we're recommending those two versus the pool enclosure.
Can we add a stipulation in our order that when 302.7, or I'm sorry, 302.7 is addressed, that it is a true barrier to inhibit access?
Absolutely.
Fine, absolutely. Agreed.
But it has to be to abate it.
So,
So we have 2 for abatement and 2,
No, you have 3 for abatement
Two
here.
for abatement.
Well, yeah, but my motion,
Your motion.
my motion said
Right.
3.
Correct.
If you want me to remove, C, I'll remove C.
That was our recommendation, is to not have C in there.
Just out of curiosity on your recommendation, why would you not, or why did you not include 13.2C?
Because we looked at it as a holistic approach for the safety of the citizens. The unkept grass and stuff is a less severe of an issue right now.
Okay.
It's not that we can't come back and do that. We also have, and we're seeking the abatement from the board, so that way it kind of speeds up the process. That's the fastest way we can accomplish this.
So we can do 2 and 2 then?
Yeah, that's fine. All right, so, then I would amend the motion to remove C and just leave it with E and the IPMC 302.7.
Correct.
can we add the language that that includes a
Absolutely.
absolute
An
barrier?
absolute barrier, absolutely.
I will second that motion.
Christian, roll call, please. Christian, before roll call, Counselor, are we good with how that was just added in just before? I want to make sure that that barrier is,
Be good, and then just to clarify on the record, a motion to take the staff's recommendation, find the property in violation, and issue an order to abate the property for the violations of 302.7 and 13-2E.
Correct.
Okay.
And defined as $250 a day if they don't,
for
Right.
each
for
violation.
each
Per
violation,
violation.
per violation.
Right, okay.
Okay.
So for clarity, after 7 days, they start accruing a daily fine of $500 for the
That's
total,
correct.
including the abatement cost.
That's correct.
Yes.
So I think the way that it is split, it would be the abatement would be the remedy for these two, and then the other two would be the daily fine.
That's how I'm, so
Right.
the abatement's the 7-day window, the fine would be the 30-day window.
Would be separate, right?
Let's understand how it works.
I think
Okay.
that's why he has two motions.
If the motion passes, the respondent has 7 days to make the repairs that otherwise, that if they choose not to make, the city will abate.
Yes.
Correct.
Right.
Okay, so they can do that. If they do that within 7 days, and they call the code inspector, and the code inspector comes and says, yes, you've done it, you're now in compliance, that goes away,
Okay.
okay?
Yeah.
If they choose not to, then the fine begins at $250 a day per violation. Actually, what we're really saying then is that there's two fines of $250 a day. So that's $500 a day on the abatements.
If I may.
Because we're only talking about the abatements.
So for the abatement ones, the remedy would be the city abating the condition on the
Correct.
property, and then the fine that they would receive wouldn't be the $250 a day, it would be the cost of the city's abatement actions.
I think it would be both. I think it would be the cost of, I think it would be the fine would be the abatement plus the cost of plus the violation until it comes into compliance.
No, so if you want to not abate and just issue a daily fine,
Oh,
that's
God, no.
okay,
No,
but
no,
the
no, no.
option for
No.
abatement, the cost that they would get would be the cost of the city's abating the.
No, so the wording in the motion, says, and charge the violator with the reasonable cost of the repairs along with the fine imposed pursuant to Chapter 162 Florida statutes.
I think here that the, kind of like the fine imposed would be the cost to the property owner.
That's,
The lien.
I think you're not, read it again. Okay. Charge the violator with the reasonable cost of the repairs along with the fine imposed.
That's what it says.
Pull it up.
Yeah, that's how it's read.
That's how I read it.
Give her a second to check.
Yeah.
Oh, absolutely.
Let me check.
Let's get this one right.
Oh, yes.
If you want to switch, I don't know if you want to switch to the other one while,
Well, no, let's,
Have it
let's not confuse it. There's a motion with a second on the floor, and let's get that resolved before we go tackle something else.
Clear as mud.
Mhm.
I should say clear as the back pool.
Yeah, that's really bad.
Did you just say it reads clear as the back pool?
Fortunately, we don't deal with these that often.
No, but
Well, I'm glad we don't.
I dealt, in my 11 years or 12 years, I dealt with them.
Yeah.
Well, no, what you're reading there is what it says.
That's
I
exactly
mean,
right.
You might think that just the fact that they're going through the abatement and they're gonna end up paying for all the work, that's fine enough.
Yeah, but they still have to, they should still pay the fine.
Yeah, well, that's what.
Of course, that's what this
that-
says.
That's what it says. Unless this is wrong. but-
No.
It's not an isolated parcel. It's in the middle of a neighborhood.
Deputy Chief. Oh, sorry, go ahead.
Sorry. Yeah, so that would work. And then adding to the motion, if the respondent fails to come into compliance by the recommended compliant date, that the city can correct the violation, which then the fines would technically stop running after the city corrected the
Correct.
violation. But,
And if it takes the city 3 to 5 days to correct it, then
yeah.
Well, that was my
Exactly right.
question I was going to ask you. If we have this motion for 7 days, does that mean that your staff drops what they're doing and runs out there on,
In this
7 days or-
situation, yeah,
okay?
as
Okay.
quickly as possible. Realistically, my goal would be to get it done
quickly.
the first day.
That day,
Yeah.
okay.
By getting the fence repaired and then at least getting the pool moving in the right direction,
Okay.
you know?
So that's still me.
Because the pool's going to take more than a day.
That's going to, that's.
The question is,
yeah.
the question we need to ask is, do we need to go to the city commission to do this? Or can this board directly order the abatement?
No, since we're doing the 13-4 from the city code, this one doesn't need to go to the commission. This is the board
Good.
ordering the
Perfect.
city to take
Perfect.
abatement actions.
Perfect,
All right,
Corrected.
good.
okay.
So then we need to change that wording then, in the motion.
If you look at page 2,
I think we're going to use number 3 on page.
yeah, number 3 on page 2, you're finding it in violation, establishing a compliance date and fine, and you're ordering work per section 13.4.
Okay, that's fine.
I think that one has the language that
That's.
would do it.
Yeah. Thanks.
I accept modifying that as my second to number 3 on here.
Okay. Are we okay
Okay.
on that?
Are we okay?
Yes, good to go. Abatement for the violations of 13-2E and 302.7.
Correct.
7 days to correct violation, $250 per day per violation, ordering the city to conduct corrective actions if compliance isn't reached after 7 days.
Perfect.
You had
That's-
verbiage
That's it. Great.
about the complete enclosure.
Yeah.
And yes, well, to correct the violation of 302.7 would require
Absolute
somehow
barrier.
completely enclosing the
Correct.
property or the pool, making
Perfect.
sure nothing can get in or out.
Thank
Does
you.
that satisfy your
Yes, it is.
request?
Yes,
Okay,
thank you.
Fine, perfect.
all right. Christian, you're up, roll call.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Aubert.
Aye.
Vice Chair Martin.
Aye.
Chair Gilday.
Aye. All right, and that brings us to another motion.
Yes, so the second motion is that,
This one should be easier.
this is simple, right? I move to find that based on the photographs, testimony from the code enforcement officer and the witnesses show that there are, show that there was a violation of Winter Spring City Ordinance 13-2C and IPMC 2024, Section 303.2, and that the respondent is in violation of the city code. I move to order response be given until March 26, 2026, to correct the violations. In the event the respondent fails to comply by this date, a fine in the amount of $250 per day shall be imposed per each violation until compliance is reported to and verified by the code enforcement officer.
Do I have a second?
I'll second.
All right. We have a second? Christian, roll call, please.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Aubert.
Aye.
Vice Chair Martin.
Aye.
Chair Gilday.
Aye. All right. Folks, thank you for coming in, and appreciate your input, and thanks for your patience on this. Well,
We appreciate it. Thank you.
No problem.
What you did, and the code enforcement people.
oh, well, you got a good gang there behind you.
Yes, we know that.
Yeah, well,
All right.
yeah, our role is to make sure that the city is safe. So thank you for your involvement.
Now we can stay in our house. Thank you.
issues here.
All right, that's done.
All right, that's the last item for tonight. We haven't been here for a while. Before we wrap it up, is there any questions, comments, concerns? Anybody have anything that needs to be addressed or that they wish to address?
Are you going to give your, Mr. President, your State of the Union?
Yeah, everybody enjoy it. God bless that soccer team.
Have a wonderful new year. Everybody be well. Stay healthy.
All right.
All right, you as well.
This code enforcement regular board meeting is now adjourned.
Keep up the